Hello class, I'm Isabella Lennox, and today I'm going to be explaining guardianship in the context of civil competence. So, as we get started, we should probably define what guardianship is and why it is important. So, guardianship is a legal mechanism by which the state delegates authority over an individual person or state to another party, meaning someone has control over you or the property you own. And within guardianship, there's two different kinds. There's plenary or general, and then there's limited and specific. So, plenary guardianships are guardianships in which an appointed person has total control over the individual, but limited guardianships, as it sounds, as you may guess already, is a guardianship that restricts the control that the appointed person has over the individual. And guardianships, in a sense, are important because they're put in place to protect the autonomy and protection of the ward, but, as we will learn, that's not always the case, but it's also important for legal and clinical relevance. Protection and autonomy. So, how does a guardianship protect a ward and also maintain the ward's autonomy? Well, after the 1980s, a lot of states made some changes to their guardianship process in order to make the process fairer and more rigorous for potential wards, meaning back before the 1980s, there was a lot of vagueness when implementing these statutes on the ward. There was also some biases from judges, lack of resources to carry out the guardianships, and more importantly, the ward themselves could not provide specific information on their exact limitations. So that kind of just left a gray area. This led to less restrictive alternatives, which less restrictive alternatives were put in place, to protect the autonomy, to allow more self-advocacy for the ward than without these less restrictive alternatives. And for example, they had advanced directives, which advanced directives allow people with mental illness to appoint a surrogate decision maker with respect to one or more specified decisions during a period of competence. I want you guys to remember advanced directives. We'll come back to that in a moment, but there was also other kinds of less restrictive alternatives that we did learn about this chapter. There was also representative pay arrangements and trust and void tenancies. Of course, those really aren't as important in civil competence right now, but they're still important for guardianship in general. Coming back to advanced directives, there's also a specific kind of advanced directives that's used in guardianships. It's called Psychiatric Advanced Directives, or PAD, and these advanced directives are designed to permit an individual with mental illness to direct in advance the type of mental health treatment he or she would or would not like in an event of incapacity. And that essentially means a person with mental illness has the choice in a capacitated state to make decisions on what they would and would not like done to them if they ever become incapacitated. And going back to what I said earlier, these advanced directives help maintain the autonomy, and in this instance, the ward's wishes are going to be fulfilled, which, allows them maybe some relief and self-esteem and self-advocacy that they're being heard and what they want done to them will be fulfilled. Some other ways to fulfill directives that we learned about in this chapter, there's living wills or a durable power of attorney, but it is essential to note that durable power of attorneys and most times living wills are for non-terminal situations or like property disputes, so meaning nothing that could be mental health treatment or surgeries, medical procedures, something like that. I also have an example of a power of attorney. When I was stationed overseas in Japan, a lot of people would buy Japanese cars or older American cars and get them shipped to America when they PCS back to the United States. But oftentimes, people have to leave their cars there. And when you leave your car there, there's still insurance on it and whatnot. So people would go to the legal office and get power of attorneys to take care of their car for the remainder of the time and then, properly sell it or give it to the junkyard and whatnot once their time comes as well. Having this example helped me understand the non-terminal aspect of the power of attorneys, so maybe hearing this example can help someone else as well. So, going back to guardianship, How does one get a guardianship, or how do they need one, right? So, guardianship is most often only determined when an accusation of incompetency is made. And so, who can be a guardian, right? A guardian can be a family member, a government agency, a social worker, a lawyer, and even sheriffs. Most times we do see it as family members, but sometimes that's not always the case. And in this case, the guardian must act in the most effective way to benefit the ward's best interest. That falls under the best interest model. And, like that's also part of protecting the individual. Make the decisions that would have the best outcome for the ward, right? How does a psychologist determine guardianship? Well, we have a few tools, and when I say a few, I mean 70 or more. And these tools, help the psychologist as best they can determine guardianship. So there's a few worth mentioning, and the first one is going to be direct assessment of functional status, or DFAS. And this tests several functional domains through 85 different activities. So the word's going to be tested on communication, using transportation, handling financial issues, and shopping, right? There's also the DFAS-R, which is a test that is a little bit more sensitive to the instrumental activities of daily living. And so if someone has reduced instrumental activities for daily living, this test might cause the psychologist to believe or think that there's cognitive impairments in the ward, when really it's not. It's just they just have a reduction or reduced instruments for daily living, right? The next one worth mentioning is assessment of capacity for everyday decision making, and this is aimed at assessing a cognitively impaired person's capacity to make decisions with regard to solving his or her own actual functional problems. Next, we're going to be talking about the challenges of guardianship. So, to begin, guardianship raises issues due to the varying implementation across the states, the failure of the courts to track the number of guardianships, and the misuse of Social Security funds by the guardians acting as representative payees for their wards. So, as you can tell, that last one, the misuse of Social Security funds, that is a big ethical no-no, right? And as we learned, representative payees is another form of less restrictive alternatives to guardianships, right? But in this sense, that person is using the representative payee, the less restrictive alternative, and almost abusing that ward, taking their Social Security funds and using it for their benefit instead of helping the ward and using it for the ward as it's intended. The next challenge is, as I mentioned in the last slide, the instruments for determining guardianship are very, very vast. There's over 70. And that can lead to the psychologist or the clinician not truly knowing all the instruments available to them, and they really can't master any expertise development with these instruments, with there being so many of them. So for my media source, I chose the news article Rethinking Guardianship to Protect Disabled People's Reproductive Rights. I have the authors listed. It was published August 2022. And so this article discusses the implications of guardianship on disabled people's reproductive rights, such as the right to contraception, birth control, sterilization, and even abortion. And this is important mentioning because forced sterilization is still legal in 30 states under certain guardianship circumstances, meaning in over 30 states, a disabled person could be forced to become sterile, meaning they can no longer have kids. And that is, ethically a big question, right? If it was someone who wasn't disabled being forced to be sterilized, of course there would be outrage, right? People would not agree. But why is it that disabled people are being forced to be sterilized? And it's, not really talked about so much. And a big part of this is the overturn of Roe versus Wade, and that already stripped every woman of their protection for reproductive rights and autonomy, but it specifically affected disabled women because they're already decreased in their reproductive autonomy. As you can tell, as I just said, a lot of them are forced to become sterilized in over 30 states, and now Roe versus Wade, let's say in the other 20 states, is now taken away, and so they really don't have that autonomy right now. So, just as we mentioned earlier, less restrictive alternatives, that also applies for this article for reproductive rights for disabled people. A big one being supportive decision making, and that's a series of relationships, practices, arrangement, and agreements designed to assist an individual with a disability to make and communicate to others decisions about their lives, right? And as we know, there's not a one size fits all model for less restrictive alternatives or just guardianship in general. But it's worth mentioning that states like Texas, Delaware, and Washington, D.C. do require written supportive decision making agreement forms for medical procedures in order for that to be legally recognized, which, you know, in turn allows that disabled person to have more autonomy over their reproductive rights, over, their self esteem, and it shows some self advocacy for themselves. So, my discussion prompt. My discussion or my question for you guys is, how should courts and clinicians handle guardianship cases when the ward's reproductive rights are at stake? Does protection outweigh autonomy in these situations? And this is my reference page, so that concludes my PowerPoint on guardianship, and I hope you enjoyed.